So again, as always, our webinar series is recorded each month, and each of those recordings can be found on our website, vgcoa.com. As I mentioned, we are moving forward with a virtual conference this year. Connect, Collaborate, Contribute Communities for the Future, which will be hosted the week of May 24th. The final format is still in the works, but currently we have a supplemental call for session proposals. A lot has happened in the past 12 months. And so we want to give those who submitted in 2020 an opportunity to update anything that was previously submitted, as well as anyone who is working on a program, research, has had experience across the Aging Services Network over the past 12 months that they believe would be a valuable part of this learning experience. We're fortunate that we've had attendees in this webinar series from across the country, and we hope with keeping the conference virtual, we will have attendees at our conference in May that are just as varied and from all areas of not only the Commonwealth, but across the country. So we hope you'll consider submitting a session proposal and joining us May 24th. If you have any questions, my email is listed there. As always, we have some upcoming sponsorship and volunteer opportunities around the conference, so we're really excited about that. I just want to share with you all, because the virtual conference is upcoming and we do have the call for session proposals and sponsorships available, I want to share with you our Governor's Conference website, which I'm sure many of you are very familiar with, but we've made a few updates. You can find all of our upcoming webinars listed under our webinar series, our previous webinar recordings here, the list of all of our wonderful 2020 sponsors that have brought us into the 2021 conference and will stay with us as we move forward. And then you'll find all the information about the upcoming virtual conference here, how you can submit your call for session proposals, which are due by midnight this coming Sunday, February 28th. Again, if you have any questions, please let me know. As we move forward into the presentation, I encourage you to remember a couple of our housekeeping rules. You have a Q&A box at the bottom and you have a chat box. Feel free to use the chat box, but as we get towards the end of the programming, we will be taking live questions and answers. So if you have questions for our presenter, feel free to put them in there. And at that point, you'll actually be allowed to unmute and turn your camera on and ask your question live, and I will help moderate that portion of the program. So before we get into Patti's presentation, I again thank you for joining us for Public and Private Guardianship in Virginia and Protection of Individuals under Virginia Guardianship Law. The webinar is going to discuss the differences between public and private guardianship in Virginia, as well as the fundamentals of the legal process for appointing a guardian. As part of this discussion, Patti will highlight some of our protections the law provides to individuals who are subject of a legal proceeding for the appointment of a guardian. Patti is going to give you some more information about herself, but she is the coordinator for the Public Guardian and Conservator program with the Virginia Department for Aging and Rehabilitative Services. So Patti, if you would go ahead and unmute yourself, and I will hand the program over to you. Thank you for being with us today.
Great. Thank you, Martina. I appreciate this opportunity. Yes, as she said, I am the coordinator of Virginia's Public Guardian and Conservator program, which is operated through DARS, the Virginia Department for Aging and Rehabilitative Services. And I am truly fortunate to work with this remarkable program. It provides support to some of Virginia's most unfortunate citizens, adults who are incapacitated, indigent, and without any other proper and suitable person willing and able to serve as their legal decision maker. I've been in this job since 2016 and have had the opportunity to watch our local public guardianship programs at work as I've traveled around the state. And I've been amazed by their commitment to their work and their clients. I have a hard time explaining exactly all that guardians do, all that the public guardians do. So DARS created a short video about the program that lets providers themselves explain their work. I'm going to show that to you in just a minute, but first, I need to provide a disclaimer, and that is the opinions that I express in this presentation are my own and don't necessarily reflect the views of the Commonwealth or DARS. What that really means is that I don't sit in a policy-making spot at DARS, so I don't feel comfortable saying that my views represent the views of the agency. So when you hear an opinion, please understand it's Patti talking about what she's learned over the years, and it's just Patti Mayer as the coordinator, not Patti Mayer as DARS. So thank you. And Martina, if you could show my video now, I'd appreciate it. The Virginia Public Guardian and Conservator Program was created by the Virginia General Assembly in the 90s to provide public guardianship services to individuals who are incapacitated, indigent, and who have nobody else to serve in the role of legal decision maker. It's operated through DARS, the Virginia Department of Aging and Rehabilitative Services.
Here we are. Guardians are unlike any other job. It's not social work, it's not exactly law, it's not medicine, but it has vestiges of every single bit of that.
DARS contracts with 13 entities across the Commonwealth to actually provide the guardianship services, and they become the guardians. DARS has funding for 1,049 slots. The individuals we serve have nobody else to make legal decisions for them.
The impact of having a guardian in your life is it affords a person to express their needs, it affords them to express their wants, and it provides an avenue in order to get those things that they need and they want and to improve their quality of life.
When people don't have guardians and need them, they are homeless. Some of them commit crimes. Sometimes they are abused. And public guardianship, while it cannot change behaviors, it can help address some of those problems.
We've had people not have access to medical care that they needed until they had a legal guardian appointed. So, it is life-saving.
In Virginia, there are over 10,000 people under guardianship. Only 1,000 of them have a public guardian. The remainder of the guardians are private guardians, and they're typically family members or private attorneys who've agreed to do the work.
I see the public guardians being very much involved, where I've worked with some of the professional or private guardians where I might see them once a year.
So while all guardians, both private and public, are subject to the court order, which describes their powers, public guardians have additional duties, and they are the only group of guardians in Virginia who are regulated.
The great things about Virginia's program that is unlike almost any other are the very features that got into the law, That was the ratio 1:20.
How do we accomplish person-centered planning? DARS does that by having a low client-to-staff ratio for public guardians and requiring the once-a-month visit with each client.
And then we do the annual reviews. We sit down with the representative and make sure that everything is being done appropriately. And we help resolve issues that come up, look down the road, and help the program to run more smoothly.
So they really have to have an assessment. They really have to review it. They really have to have a values history. No state has anything like that.
When we act as a guardian for an incapacitated adult, we visit them, we make sure that their medical care is taken care of, make sure their benefits are in place, we get them to the best possible living situation that they can afford, make sure that they have clothing and food, and that they feel that they have a person in their life they can count on.
I believe that a guardian needs to be empathetic and patient.
Have very strong communication skills.
Kindness, compassion.
Knowledge of the system, the legal system, the financial system, social service system, medical system.
To see, are their clothes fresh? Do they need some new shoes?
Come and see you when you don't want to take your medication. setting up services, outside resources.
Being ready to answer the phone any time of the day or night.
And the willingness to listen to others.
To dig deeper, not just do what's necessary to make decisions for people.
You would need tough skin.
You have to be ready to go into battle.
We work with so many other agencies.
We deal with transportation companies.
All of the Medicaid managed care organizations.
Attorneys.
The Department of Behavioral Health and Developmental Services.
Job coaches.
Dentists.
Group homes.
Banks.
Vital records.
Social Security.
The doctors, the psychiatrists, the psychologists.
And of course, nursing homes.
It's a multitude of things that a guardian does. And we try to put them in one box, but it's not that simple.
The Public Guardianship Program requires that our guardians use person-centered planning, also that they visit clients at least once a month, and that is the minimum. So what they become is the constant.
Having somebody who has that patient's interest at heart, who has the authority under the law to consent to what they need for their treatment, is a really important part for us.
Guardians and conservators are legal decision makers. All guardians and conservators have a fiduciary duty to act in the best interest of the incapacitated person.
We are working for them, but we are going to be a consistent face throughout their lives. It's easy to make this feel familial.
So having that person-centered planning is really helping the person come up with a plan that's going to address all the things that are important to them, as well as the things that are important for them.
And they think through what that actually means. So it's not what the guardian thinks would be good, it's what the client thinks would be good.
I have witnessed clients engage in care plan meetings. They have mentioned wanting to get jobs, wanting to volunteer, wanting to be more active.
Our misconception is that guardianship is for the rest of a person's life. While that is typical, because most of the things that lead somebody to be incapacitated are irreversible, it's not always true. And in that case, we can bring the matter back to court and ask a judge to restore the individual to capacity.
I basically met my first guardian in the hospital. Yeah, we hit it right off. She would always give me a lot of encouragement and stuff, and we're just like family.
They want people to do well, but then they think through what that actually means. So it's not what the guardian thinks would be good, it's what the client thinks would be good.
She always said your goal is to get out of the hospital, right? I said, yeah. And your goal is to be on your own, yeah. And I've succeeded in all of that.
We're not able to be their voice unless we truly understand them and we can stand in their shoes.
But I have my own apartment. I've been in my own apartment for 4 years, and I pay all my own bills.
What DARS measures are the superficial metrics governing the program, which, while they are important, are not the heart of the program. The heart of the program is the relationship that our guardians develop with their clients.
One of the ways I think public guardians really add to the life of the individual is they develop a real relationship and knowledge of that person.
You have to care deeply. I mean, that if you don't, then it is very hard to stay motivated.
I felt like I've been sleeping all my life until I got this job.
Individuals at the hospital at 11 o'clock at night, that guardian came out, to help make decisions on the spot.
Individuals are really happy to see their guardians and show off things like their Special Olympic ribbons and, awards that they may have received when they were at work.
I've been seeing this client for 4 years. And then I walked into the group home where she lived, and she grabbed my hand and she put it to her heart. And the day that she did that, you could have just knocked me over with a feather.
She really cared about me as a human being, I think if I hadn't had them, I don't think I would have made it to where I am today.
So thank you, everyone. I'm sorry if the sound was a little off, you know, technology. It's a little bit tricky, but I hope you were able to hear it. If you missed it, it is on the Virginia Public Guardianship website, and you can see it there. It's also on our YouTube channel. I would say that on my screen, you couldn't see quite everybody who was speaking. So I would just explain that the Cindy who spoke, the client is someone who was restored to capacity. She's a client that we had just for a short time. Well, not for a short time, but for quite a while. And as her condition improved, we were able to get her restored to capacity, and she was able to speak on behalf of the program. So I've been asked today to talk primarily to you about the differences between public and private guardianship in Virginia. There are important differences, and you heard about them in the video. I'll go over them again. Next one, Cecily. I'll go over them again and hope that this will reinforce some of the ideas and not just feel like repetition. But before I talk about those differences, I want to go over about some of the fundamentals of how guardianships are established in Virginia. For some of you, this will probably be very basic, but truly, as I travel across the state, I find there are many misconceptions about how guardianships are established, even among people who provide social services to individuals with diminished capacity. So I'm going to try to quickly explain the role of guardian and conservator, the legal process for establishing a guardianship, and the protections provided by Virginia law to allegedly incapacitated adults who are the subject of a guardianship proceeding. After I've gone over these fundamentals, I'll talk about public versus private guardianship. Just one more housekeeping measure, and that is in Virginia, as you probably know, a guardian and a conservator have different roles. For simplicity's sake, I'm going to use the term guardian throughout most of this presentation, but when you hear me say guardian, what you should think is guardian or conservator or both as appropriate. So it's a truism in my business, in this business, that guardianship is a nuclear option. We say that because guardianship is a legal remedy designed to provide assistance to adults who don't have the ability to process and understand the information necessary for normal adult decision-making, and so are unable to take care of their own needs. In a guardianship proceeding, a Virginia Circuit Court appoints a responsible person or entity to serve as the guardian, and this person or entity is given a legal obligation to undertake decision-making on behalf of the incapacitated person. Guardianship is referred to as a nuclear option because it places the incapacitated person in a status similar to that of a child. Generally, a person found to be incapacitated by a court can't enter into a contract, can't give consent, so for example, can't consent to medical treatment, and unless preserved by the court, a person who is found to be incapacitated loses the right to own a gun, marry, vote. Consequently, this is a remedy that should be applied very carefully, only when there aren't workable alternatives. It's important for people who want to avoid guardianship for themselves to plan early while they still have capacity. I don't have time today to discuss all of the alternatives to guardianship, but this slide includes some recommendations from AARP. The next slide lists some additional tools that can be used to avoid guardianship or to assist someone with diminished capacity if a guardianship is not in place. So why would you appoint a guardian? Typically, a guardian will be appointed when the informal support systems for someone are no longer effective. Informal assistance is great, and when it works, it works. But generally, it's voluntary. The person providing assistance may only occasionally be helpful and is not generally accountable. Someone who may be willing to do a good deed for someone one day may not be available the next week. Also, there may be disagreements among the individuals providing assistance. We see this when siblings disagree over a parent's care. It's Also sad to say, but informal decision makers, even family members, may not always act in an individual's best interest. For example, a local DSS office may seek a guardian when it finds that an adult child is abusing or financially exploiting a parent incapacitated by dementia. Of course, many incapacitated individuals just don't have anyone else in their life to provide support. For a power of attorney or an advance directive to be valid, the beneficiary granting the power must have capacity. We see many cases in which a person has simply waited too long. Family members begin talking about setting up a power of attorney after their parent begins to exhibit cognitive problems, for example, but it may just be too late. The parent may have declined to such a degree that they've lost their power to agree to a power of attorney or an advance directive. In this case, it may be necessary to create a guardianship so that the person seeking to provide assistance has the legal authority they need to act on behalf of the incapacitated person when dealing with the person's bank, residential provider, or physician. A guardian will be appointed by a court when an individual's executive function is so impaired they can't understand and process the information necessary to manage their personal affairs. A guardian's powers are established by a court. The powers may be individualized to meet the needs of the incapacitated person. A guardian may be given the power to undertake all decision-making related to the personal affairs of the incapacitated person, other than those related to finances, or to make decisions only in a few areas, like medical decisions. The power may be granted for an indefinite period of time or maybe only for a limited period of time. A guardian has a duty to act in the best interest of the person under guardianship. The guardian's power is balanced by code requirements stating that a guardian must, to the extent possible, respect the wishes of the person under guardianship and encourage the person's independence in decision-making. A conservator may be appointed by a court when an individual's executive function is so impaired that they can't manage their finances or financial affairs. A conservator is appointed to manage the person's assets, income, and expenses. All conservators have a fiduciary duty to the person under conservatorship. A court may appoint a guardian and a conservator, or it may just appoint a guardian or just a conservator. A guardian and conservator may be the same person or entity, or the roles may be held by different individuals. Because finding a person to be incapacitated is such a serious and consequential action, the Virginia Code provides a detailed legal process that includes important protections for the rights of the allegedly incapacitated person. In my work, we receive referrals from people and entities who are desperate for a quick solution to a problem, and assume that obtaining a guardian is done by simply enrolling the allegedly incapacitated person in a program or signing them up with a guardian. This is not the case. Obtaining a guardian requires a decision of a Virginia Circuit Court through an evidence-based adversarial legal proceeding. It begins with the petitioner who brings a case alleging that an adult, the respondent, is incapacitated and in need of a guardian. Any person or legal entity can file a petition and make the case. Typically, it's someone who believes the informal support systems the individual has been relying on are no longer effective. It might, for example, be a family member, a hospital providing medical services, a residential facility. In cases of abuse, neglect, or financial exploitation, a local Department of Social Services might initiate a proceeding. Or it might be a community services board providing support services to an individual who has an intellectual disability or who struggles with a serious mental illness that is chronic and debilitating. The code definition of an incapacitated person explains that to be incapacitated, a person must be incapable of evaluating and receiving information to such an extent the person does not have the ability to meet the essential requirements for taking care of their health, safety, daily care, or therapeutic needs. This will lead to the appointment of a guardian, or to manage their property, assets, or financial affairs, which will lead to the appointment of a conservator. The code explicitly states that poor judgment alone is not sufficient evidence to find that an individual is incapacitated. I want to point out here that a determination of incapacity in this context is an individualized legal determination made by a court based upon evidence. There is no definitive agreed upon standard, and it is not a determination made by a physician or a psychologist, although the opinion of a physician or psychologist may be considered as evidence during the proceeding. The petitioner in the case should provide evidence to the court supporting the petitioner's argument that the respondent is incapacitated. Generally, this is a report prepared by a licensed professional discussing the respondent's diagnosis and prognosis, whether medication could affect the person's behavior or demeanor, and the person's ability to learn self-care. The Virginia Code requires that the respondent's relatives receive notice of the proceeding and a copy of the petition. These include their spouse, adult children, parents, and siblings, or if no such person is known to the petitioner, 3 other relatives, which can include their stepchildren. If 3 relatives can't be identified or located, the petitioner must certify this fact to the court. And this is provided to give the family an opportunity to intervene and participate in the proceeding. The allegedly incapacitated person must personally be given notice of the hearing. This slide provides details about what must be included in the notice. A guardian ad litem is appointed to represent the allegedly incapacitated person's best interest. A GAL is an attorney subject to all the ethical rules and professional standards of the Virginia State Bar. A GAL must have completed a training program approved by the Virginia Supreme Court. In addition to having a GAL, the allegedly incapacitated person also is entitled to an attorney to represent their wishes in the proceeding. Typically, this would be an attorney who would present evidence to show that the individual is not in need of a guardian or suggesting limitations to the guardian's powers. The allegedly incapacitated person has a right to a jury trial upon request. The allegedly incapacitated person has a right to be at any and all hearings. Now, the GAL plays a very, very important role in the proceeding. Because of time constraints, I am not going to go into what the code actually requires of GAL in a guardianship proceeding, but I've given an overview of the requirements in the next 2 slides. What factors should the court consider as it decides whether to appoint a guardian? The code requires the court to consider the respondent's limitations, whether the person's needs can be met through less restrictive alternatives, how the respondent might best develop maximum self-reliance and independence, the need to use guardianship to protect the person from abuse, neglect, or exploitation, and the suitability of the proposed guardian. In establishing the powers of the guardian, the code states that those powers should be designed to permit the incapacitated person to care for himself and manage his property to the extent of his ability. And it's important to remember that everything that's been decided in a guardianship proceeding can be changed in a subsequent court proceeding. The powers of the guardian can be modified. The person serving as the guardian can be changed. The person under guardianship may be restored to capacity and the guardianship terminated. But none of these changes can be made without a court proceeding. I'm not going to go into the details of conservatorship, but you can see an overview of this on slide 23. And now I want to talk about the differences between public and private guardianship in Virginia. First, there is a very common misconception that anyone who has a guardian who's not a family member has a public guardian. This is not correct. The Virginia Public Guardian Program is a small program operated through DARS. DARS contracts with 13 organizations across the Commonwealth to serve as public guardian, and sometimes as a public conservator for 1,049 incapacitated individuals. DARS itself never becomes the guardian. The entity that DARS is contracted with becomes the guardian and is the entity that has the legal decision-making authority. All public guardian clients must be found by a circuit court to be eligible for the program. That is, the court must find that the individual is incapacitated and without sufficient funds to pay a private guardian. We shortcut that to say indigent. There must also be no other proper and suitable person who has come forward during the guardianship proceeding who is willing and able to serve. Now, just a word about indigency. The code addresses how this is determined. Generally, if an individual would be entitled to a public defender or court-appointed defense counsel in a criminal case, the court should consider them to be indigent for the purposes of appointing a public guardian. There is also a rebuttable presumption that a person who is receiving assistance from a state or federally funded program for the indigent meets the indigency criteria for public guardianship. An example of a federally funded program for the indigent would be SSI, Supplemental Security Income, but not Social Security retirement benefits. Now, this doesn't mean that someone whose sole source of income is SSA retirement wouldn't be eligible for public guardianship. It just means that they're not entitled to the presumption. I also want to say a word here about public conservatorship. Because most public clients have to be indigent, our providers rarely serve as public conservators. The code indicates that a conservator is not required if the majority of the incapacitated person's income is from Social Security or another government program, and the incapacitated person has a representative payee to manage those benefits. That said, an individual may have a home that needs to be sold so that the proceeds can be used to cover the cost of residential care for a period of time. Or the incapacitated person may have bank accounts that need to be managed. In that case, the court might appoint a public conservator. Normally, conservators are compensated from the incapacitated person's assets. A public guardian program acting as a public conservator can't receive any compensation from the incapacitated person's assets. For that matter, neither can a public guardian. Approximately half of our program's slots are reserved for individuals referred from a community services board who are incapacitated by an intellectual or developmental disability. 98 of our slots are reserved for individuals coming out of state mental health institutes referred by the Department of Behavioral Health. Our remaining slots are unrestricted. These are primarily filled with individuals incapacitated by dementia or a traumatic brain injury, also with mental health difficulties that aren't coming from a state hospital. Now, it's estimated, you heard in the video, that more than 10,000 adult Virginians are under guardianship. No more than 1,049 of these are public guardianships. The remainder of them are private guardianships. Private guardians are most likely to be a family member or an attorney. Now, this can be surprising. A contract with DARS to operate a public guardian program does not mean that all guardianships provided by that legal entity are public guardianships. An entity that is contracted with DARS to provide public guardianship services also may operate a private guardianship program. Clients that are served through these private programs are not public guardianship clients. So let's talk a little bit about the differences. We have wonderful private guardians in the state. And of course, you know, I think all my public guardians are wonderful. But all guardians, both public and private, are obligated to do the following as they act as a legal decision maker for the individual. To the extent feasible, encourage the incapacitated person to participate in decisions, to act on their own behalf, and to develop or regain capacity to manage their personal affairs. Consider the expressed desires and personal values of the incapacitated person to the extent known. Act in the incapacitated person's best interest and exercise reasonable care, diligence, and prudence. Not unreasonably restrict an incapacitated person's ability to communicate with, visit, or interact with other persons with whom the incapacitated person has an established relationship. And to maintain sufficient contact with the incapacitated person so that the guardian can know their abilities, limitations, needs, and opportunities, and to visit with the incapacitated person as often as necessary. In addition, all guardians, both public and private, must file a report annually with the DSS office that serves the jurisdiction where the incapacitated person resides. The annual Guardian's report describes the incapacitated person's living arrangements and the mental, physical, and social conditions affecting the incapacitated person, the medical, educational, vocational, and other professional services the person has received during the reporting period, the number of visits the guardian has made and the nature of the visits, and whether the guardian agrees with the person's current treatment plan. It also requires the guardian to address the guardian's recommendations for the coming year and the guardian's compensation. If a guardian has not filed the guardianship report within the required time frame, the court may summon the guardian to court or issue a motion to show cause why the guardian should not be held in contempt. In the case of conservators, inventories and accountings of income and expenses must be filed with the local commissioner of accounts. Now, in addition to all of that, public guardians are subject to state regulations and a contract with DARS that governs many aspects of the services provided to the clients of the public program. When acting as a public guardian, the guardian must make a face-to-face visit with every public client at least once a month, have a client-to-staff ratio of no more than 20:1, maintain certain documents in the files of public guardian clients, which includes a guardianship care plan, a current assessment of the client's condition, a values history report, which is a document designed to assist with understanding the client's preferences, and a record of client visits. Public guardians are required to utilize person-centered planning. They must attend DARS-sponsored trainings. They participate in a DARS auditing of each program, and this is generally conducted at the offices of the local provider. And they must respond to DARS complaint process. Private guardians are not subject to regulation by the executive branch of Virginia's government. They are not subject to the oversight of any state agency. The only remedy for those having a complaint about the work of a private guardian is to bring the concern before the circuit court that appointed the guardian, or if the guardian's behavior appears to constitute abuse, neglect, or financial exploitation, to file a complaint with Adult Protective Services. Of course, these remedies are also available to individuals who are concerned about the work of a public guardian, but I would say that the DARS complaint process will likely provide a quicker route to resolving an issue. There are some additional aspects of the public guardian program that provide further protection to the program's clients. Each local public guardian program is required to have a multidisciplinary panel made up of volunteers from the community who generally are experienced in handling social service needs of public guardian clients. This panel can provide helpful guidance and advice to the local public guardian program as it considers how best to serve each client. Additionally, before agreeing to serve as a public guardian, each local public guardian program is required to consider, in collaboration with its multidisciplinary panel, whether the appointment of a public guardian is appropriate. In other words, does the referred individual appear to meet the criteria established in the code? And is the guardianship the least restrictive alternative available to assist the person? The public guardian provider should recommend limitations on the power that it's granted as guardian if such limitations are appropriate. Also, each provider is required to consult with its multidisciplinary panel and review all public guardianships annually to ensure that the appointment continues to be appropriate. So in summary, there are differences between public and private guardians, but you can boil it down to this. Public guardians are regulated by the state. Private guardians are not. Public guardians and private guardians are all subject to the court and the judicial branch of government. The performance standards mandated by the state for public guardians do not apply to private guardians. And then Virginia law does provide significant protections to individuals who are alleged to be incapacitated and in need of a guardian. And these are the court process, notice to the person, notice to the family, the appointment of a GAL, the right to have a second attorney, the right to a jury trial, court consideration of the individual's needs and circumstances, limitations on the powers of the guardian conservator, and of course, the orders may be changed as circumstances changed. So I just want to leave you with these thoughts about guardianship in Virginia. Again, the purpose is not to deprive people of autonomy, but to designate a person who will be legally responsible and accounting for acting to protect a person who is incapacitated and lacks the understanding needed to care for themselves. But guardianship is a very serious deprivation of an adult's rights. It makes the person similar to a child in the eyes of the law. Guardians and conservators have tremendous power over the life of an incapacitated person. Therefore, guardianship should always be considered as the nuclear option. When the tool of guardianship is needed and is used properly, it can be a tremendous benefit to the individual who is served. But it is a tool that should be used carefully, and those providing guardianship services should be held to a high standard of care. On the next page, I've provided some contact information about where you can find us, a link to our webpage. On that webpage, you can find not only information we've provided, but a link to information that the Virginia Supreme Court has provided with the basics of guardianship. And then you can see the codes and regulations. The first one, 64.2 from the code, applies to all guardians and conservators, and then the next two are just for public guardians and conservators. And now I am happy to answer questions. Martina.
Wonderful. Well, thank you so much, Patti. We've had several questions come in. So we'll move through questions. Again, as a reminder, you can either select the raise your hand icon and we will call on you to ask your question, or you can type your question in the Q&A box and I will call on you to unmute and turn your camera on to ask your question directly to Patti. First, I'm going to allow, our first question will come from Jessica Young. Jessica, if you could go ahead.
Yes, my question is, what is the process for submitting a petition? Is there a standardized form? Must it be taken to the circuit court? Excuse me, or is there an electronic submission process? Who can submit one? Like, does it have to be a lawyer? And is there like an organization or resource to assist us with applying for guardianship?
No, there isn't. And generally, it's a circuit court proceeding. Just in my experience, most people feel that to be properly represented in circuit court, they like to have an attorney with them so that all the proper evidentiary rules are followed and they don't get out-lawyered in some way. It's good to be represented in circuit courts. While circuit courts will hear cases without pro se cases without representation, I think generally people feel more comfortable in circuit court with an attorney. Guardianship is a legal process, and so I would say if you are thinking about guardianship, you should definitely consult with an attorney. It is a creation of the code. It's run by the courts. It's very important to get legal representation. Any individual, the code says that any person or entity can be the petitioner. but the petitioner needs to be prepared to make its art, just as you would in any other civil proceeding. You need to prepare to be prepared to make the arguments to support your case. There are no standard forms, no. So anything else? Any follow-up on that?
No, thank you.
All right, our next question is going to be from Laura Pilati. Laura, you can go ahead and unmute yourself and ask your question.
Hello, can you hear me?
Yes.
Yeah.
Hi. So we work with a lot of folks to help with early advanced care planning, and many of the people that we work with are socially isolated or just do not have anybody personally that they feel they can name as a decision maker for themselves. And so I often get the question about, what can I do to really protect myself? I'm planning now. I don't need someone to speak for me now, but I'm worried that in the future I could. And so I don't know if there's any way to, whether it would be the person would be most appropriate for public or private guardianship. I don't know if you can speak to both situations, but just anything that folks who are planning in advance can do to really set themselves up to be protected and respected in these kind of situations.
Yeah, I would go back to the AARP slide. They actually have provided quite a lot of helpful information. I think it begins by planning ahead and trying to have a good relationship with a person that you trust. They recommend setting up powers of attorney and medical powers of attorney. They indicate in there that you can build protections in so that there are checks so that some other trusted person is making sure that the power of attorney, the person with the power is reporting to someone else, so that you can create checks and balances. And of course, a good elder law attorney would be able to help you with that, or disability rights attorney would be able to help you with that. So there are guidelines. You can even, I guess, indicate who you might want to serve as your guardian someday, if that becomes necessary. But it basically involves that advanced planning. And of course, not everybody has somebody who can do that for them. The difficulty comes when you're in a situation. Oh, I do want to mention this. The Virginia Healthcare Decisions Act does provide a list of family members who can make medical decisions for you. The difficulty with that it begins with a guardian and then it goes to spouse, and then to adult children. The difficulty is when family members don't agree, right? So if somebody's children are making the decisions, they don't have a spouse, and the children disagree, it puts the medical provider in a tough spot there, right? Who are they supposed to listen to? So having a guardianship in place will allow it to be clear who the decision maker should be. So these can be very difficult situations. A lot of people simply don't have somebody who can make decisions for them. If you're dealing with a bank, maybe the bank informally will say, oh, we know Joe Smith and you're his son and you've always been in here and we know you're his son. And so, yeah, okay. But they may not, right? If they think that Mr. Smith is now incapacitated, they may not trust the son. If the son isn't on the bank account, what is the bank supposed to do? So guardianship makes it clear to the third party who has the power to make the decision. So the alternatives basically are, putting somebody else in your bank account, setting up powers of attorney, maybe having a representative payee. If you have somebody who just can't manage their finances, maybe they have enough money to pay a representative payee to handle their income, handle their Social Security benefit for them, or a personal bill paying service.
Can I just clarify really quick that I'm asking about folks who really do not have anyone? Are there programs out there that folks can make arrangements with in advance before they might get to an incapacitated state?
I don't know. I mean, I know there are plenty of bill paying services and representative payee services. I don't know of programs that would say, I will volunteer to be your power of attorney, to be your attorney and act under a power of attorney.
Okay, thank you.
And of course, I do have to speak to this. One of the difficulties, of course, not all of these people are indigent. One of the difficulties, of course, is that we think there might be people out there to help who are not relations or friends. Those people typically want to be paid for the work they're doing and need to be paid for the work they're doing. So that's something else to think about.
All right, thank you. We have several questions, and I'm going to try and lump them into one question for you so we can knock out several together. There's several questions about there are only 1,049 slots. Is there a waiting list? Can you speak to the waiting list? Is there a need to increase those slots? I guess that would speak to the waiting list. And is there a future for increasing those slots? I've gotten several questions come in about that.
Yeah. Well, we had a big increase in 2017 and 2018. We haven't had any increase since then. We do have a waiting list. Our programs are located across the Commonwealth, and we give each program a certain number of slots. So if you live in Roanoke, for example, Family Service of Roanoke Valley is the program that we contract with to provide services in that area. Their waiting list may be different than what Jewish Family Services of Tidewater has, and they serve the Tidewater region. But it's based on where the individual under guardianship resides. It would help if we had a demographic study that helped back up the need for more public guardianship slots. The General Assembly hasn't authorized a study like that, but just knowing the need, it's an aging population. Not all people who are aging have friends or relatives who are able to fill this role. Many of them will be indigent. I think it makes sense that there will be a need for more public guardianship in the future. And the General Assembly would be the one to provide funding for that.
All right, thank you. I'm gonna allow Jennifer Colbert to ask the next question. You should be able to unmute yourself, Jennifer.
Hey there, can you hear me now?
Yes.
Okay, so just sort of two real quick clarifying questions. So if a person is indigent, sorry, I can't pronounce that, will an attorney automatically be appointed, or do they have to request for that?
Typically the petitioner recommends who they would like to be the guardian.
Okay.
So if it's a public guardian, to apply to our program, am I still on? Okay, to apply to our program, we have a website, and on the website you can, there's a universal application form. You would fill out that referral form and send it to the local provider who's providing public guardianship services in the community where the person lives. You would go to court if the local provider agreed to accept the individual into public guardianship services. They would tell you as the referring individual, now's the time, go to court, explain your case to the court, persuade the court that this person is indigent, ask that we be appointed, and we will agree to serve if the court chooses to do that.
So it's the
so that's the process.
requesting.
Yes, it's the petitioner. The petitioner is the one seeking all of these services out. Yes, DARS does not, the state does not bring a case asking for somebody to be placed under public guardianship.
Sorry, my question was, so is the appointed attorney for the petitioner then, or is it for the individual that is?
Oh no, the GAL is representing the respondent, and they're appointed by the court.
Okay, thank you.
So they're representing the allegedly incapacitated person. Sometimes in family guardianships, most particularly, there's nothing that prevents a family member from bringing a guardianship case and themselves being appointed as the guardian.
Okay, and then the second clarifying question is for private guardians. There's really no parameters for them in terms of what they are legally obligated to do for the client or for the individual under guardianship.
Mm-hmm.
So there's no legal parameters for what a private guardian is supposed to do or not do.
Well, the order will describe the powers of the guardian. The order establishes the power of the guardian. So it will say, it would be very typical for the order to say, make all legal decisions necessary to care for the person. This would include residential decisions, medical decisions, and describe generally what the scenario would be. Of course, now our clients have nobody else to serve, right? And public guardian clients, their incapacity is usually very clear. They've really, they're at a point in which they need help with a lot of things. And you could have a contested case where people are arguing about what the extent of the powers of a guardian should be. They might say, one sibling might say, I think mom needs help with her medical decisions, but she doesn't need help with deciding where she wants to live, right? So the court order can be tailored to that person's needs. That's actually why, one reason it's in the court, so it can be individualized and the guardian's powers can be targeted to what that person needs help with.
Okay, that makes sense.
And a judge can
Great. We're going to take one more question live to be conscious of people's time, and that'll come from Janet Brennan. And then we will spend a few minutes with wrapping up, closing comments and next steps. So Janet, you can go ahead.
Thanks, Patty. This has been a wonderful webinar this afternoon. But my question comes with the private guardians. What advocacy initiatives can we take or that can be taken here in the Commonwealth of Virginia to ensure that private guardians are held accountable for their role and responsibilities on behalf of that individual under that guardianship? For example, once the private guardianship is completed, Department of Social Services is out of the picture if they've been in the picture with a private guardianship. So how can private guardians be monitored to ensure that they are doing what they need to do for that individual, or what can we do from an advocacy perspective?
Mm-hmm. That's an excellent question, and I don't want to create the impression, I don't want to be critical of private guardians because some of them just are extraordinary, but we all know there's been a lot of press about difficulties with private guardianship. So your concern is something that people are very aware of. Every legislative session for the past few years, many bills have been presented to address this issue. And in fact, I would say that there is so much concern and momentum about the issue. You may be aware that JLARC, the Joint Legislative Audit and Review Commission, which is permanent staff to the General Assembly, has been charged with writing a report on guardianship in Virginia, which is due to the General Assembly in November. And they are undertaking a comprehensive study of not only how guardianship works in Virginia, but I know they're looking at other states and how they manage guardianship. And I feel confident that this is going to be one of the issues they're considering. In addition, Virginia is part of the WINGS process, and WINGS is a panel in Virginia. It was organized by the Virginia Supreme Court because guardianship is so peculiarly belongs to the court system. So they set this up, and it is the working interdisciplinary network of guardianship stakeholders. It's a large organization made up with people who have an interest in guardianship from different perspectives. And I'm on that as a representative for DARS. We meet regularly to discuss issues surrounding guardianship in Virginia. So I would say writing to the Virginia Supreme Court might be another avenue to just at least register your concerns, although I'm not sure they have a solution. I guess guardians could be made to come report to the court more often. And I do want to correct an impression I probably gave. It's not that DSS offices are completely out of it. DSS offices do get the report of the guardian, and the local DSS offices can read the report of the guardian to see if there are red flags there that give them concerns that maybe the guardian isn't doing their job. I've heard them say that sometimes a guardian will just photocopy their report year after year and send the same report in. That would be a red flag that maybe the guardianship isn't working very well. And then DSS might start poking around and start asking some questions just to make sure that the person isn't being abused or neglected. But of course, DSS's role is limited to responding to situations where they find abuse, neglect, or financial exploitation. But yes, I would say those are the avenues. Virginia is aware. You can find wings through the Virginia Supreme Court, and keep talking to your legislators.
Thank you.
All right. Thank you, Patti, so much for joining us. Again, we've shared Patti's contact information. Many of you have asked about the recording and about the slides, and we have numerous questions that we just didn't get to. So we'll work with Patti to get some of those questions answered that we didn't get to live. In the next 24 hours, you'll get a follow-up email to this webinar that will include any of the pertinent information, such as slides and answers to questions, as well as the link to the recording of this webinar. Also, I just want to encourage everybody again to join us in the next month for our webinar, the fourth Tuesday of every month. In March, we'll be talking about elder fraud and abuse with the Senior Medicare Patrol Program. So we hope you'll join us. Again, please visit our website, vgcoa.com, or contact us for any questions about our open call for session proposals. And we look forward to seeing you again in a couple weeks. Thank you so much, Patti. It was wonderful to have you, and your presentation was fabulous.
Thank you. And everyone, feel free to give me a call. I'm happy to share whatever I know.
Awesome.
Thank you.
Wonderful. Thank you, guys. We will see everybody soon.
Bye-bye.